This is Frank Sheeter, and this is a presentation for healthcare providers on dealing with overpayments. Healthcare providers that identify overpayments from government programs like Medicare and Medicaid can violate the False Claims Act if they don't report and repay such overpayments within 60 days of identifying them or the deadline for a corresponding cost report. Providers can have this False Claims Act exposure even if they received an overpayment innocently. The Fraud Enforcement and Recovery Act of 2009, or FARA, made retention of any overpayment an obligation that is subject to the False Claims Act, or FCA. PAPACA, or the Healthcare Reform Package, requires providers to report and return Medicare or Medicaid overpayments, either within 60 days of identifying them or when the corresponding cost report is due, if applicable. Retention of overpayments past these deadlines poses risk to providers under the False Claims Act. Here's the relevant passage from the Healthcare Reform Law. It says that a person, which includes, of course, an entity that is a provider, if a person or an entity has received an overpayment, the person shall report and return the overpayment to the Secretary, the state, an intermediary, a carrier, or a contractor as appropriate at the correct address. Moreover, the provider must notify the Secretary, state, intermediary, carrier, or contractor to whom the payment was returned in writing of the reason for the overpayment. An overpayment must be reported and returned to one of those agencies or payers by the later of either 60 days after the date on which the payment was identified or the date any corresponding cost report is due, if applicable. If the payment is such that it has a cost report implication, providers may have a longer time to reconcile the overpayment. Here's the link between the Reform Act and the False Claims Act. If you notice, the word obligation is highlighted in red. And under the Reform Act, it says any overpayment retained by a person after the deadline, the 60 days or the cost report deadline, is an obligation as defined in the False Claims Act. We'll see in a minute what that means. Here's the False Claims Act provision. The word obligation is also put in red here so you can see the tie between the Reform Law and the False Claims Act. And this says that a provider that avoids or decreases an obligation to pay or transmit money or property to the government, in other words, if they avoid an obligation to repay an identified overpayment, they're liable under the False Claims Act for the standard False Claims Act penalties. Of course, False Claims Act liability hinges on knowing retention of an identified overpayment. So we need to look at the term knowing. The definition in the False Claims Act is that knowing or knowingly occurs when a provider has actual knowledge of information, acts in deliberate ignorance, or acts in reckless disregard. Importantly, there's no requirement that the government, or a whistleblower for that matter, prove any specific intent to defraud the government in retaining an identified overpayment. There are several determinations that a provider who may have an overpayment has to make. First of all, when have you identified an overpayment? Is it when you first have a question or a concern that you may have been overpaid? Or is it later after you've had a chance to validate and quantify any specific overpayment? Second, to whom do you report and repay the overpayment? The statute says that you can report and return to the Secretary of HHS, the state, an intermediary, a carrier, or a contractor. You've got to make that decision very carefully as to who the appropriate recipient of the report and the repayment should be. Third, what is the reason for the overpayment? Of course, you have to describe in writing the basis for the overpayment, and I would say you also have to indicate or should indicate the steps you took to prevent overpayments from occurring in the future. What are some suggested approaches? First, act promptly when you suspect an overpayment. Time is not on the provider's side in these circumstances. Second, learn how your payers handle repayments. Each payer has a little different approach to it, and you need to learn how they expect repayments to come in, whether there's a certain form, whether there's a certain address, etc., whether certain things have to be included in your notification. Learn that ahead of time so you don't get bogged down at the end on those details. There's also a difference between suspecting or investigating a potential overpayment and actually identifying and quantifying it. Document your processes and your investigation and your review so you can make a distinction between those two very different concepts and support the fact that you made a timely report and repayment. Consider getting counsel involved. Because there are False Claims Act implications now associated directly with the retention of overpayments, prudent providers will have counsel involved in designing their policies and protocols for addressing such issues, and will get them involved if there is a significant or material set of overpayments that need to be addressed from a legal risk standpoint. Have a written policy and procedure and follow it. And finally, correct your recognized weaknesses, and of course, always document your activities and your timelines as you go through any process to quantify and validate potential overpayments. You can review the False Claims Act provisions that I've been discussing at 31 U.S.C. 3729. You can review the PPACA or healthcare reform excerpts that I've been discussing at 42 U.S.C. 1320A 7K. Please take a moment to provide feedback as to whether this presentation was helpful and whether you would be interested in more presentations like it. And thank you for listening.